FORA.tv. The world is thinking.
It's impossible to predict how the courts will decide a case like this. I think that you have a lot of legal precedent, but none of the precedent is directly on point in the federal courts. You have the federal courts not only in Loving against Virginia that held it unconstitutional to bar interracial marriages, and that was at a time when almost 30 states prohibited interracial marriage. So it was a situation where the Supreme Court stepped in and outlawed state laws that existed in a lot of places. You've had Supreme Court cases that hold that a state cannot forbid prisoners from getting married, cannot forbid people who abuse their spouses or fail to pay child support from getting married. There have been a series of cases in which the courts have expanded what they have defined as the fundamental right to marriage. Now, those questions are going to now devolve to the issue of, do those precedents apply when you have two people who are not prisoners, who are not spouse abusers, who are not scofflaws, but whose only distinguishing characteristic are their sexual orientation? And I think that from an equal protection argument, from a constitutional argument, that's a very strong argument. Now, that's not to say that people can't believe that marriage should be between a man and a woman. I think that there are people, and I accept this, that genuinely believe, for a whole series of reasons, including religious, that marriage should be between a man and a woman. Our First Amendment to the Constitution gives those people the right to believe that and the right to pursue that. But that same First Amendment says they do not have the right on those grounds to impose those views on other people. There's both a free exercise clause and an anti-establishment clause in the First Amendment of the Constitution. And I think that if the Supreme Court decides it, you will have uniformity. If not, you're going to have a state-by-state battle.